Okay, looks like people are coming into the room, so I'm going to go ahead and get us started, Jim. So greetings, everyone. Thank you all for joining us today for our webinar titled How to Handle Export Violations, including subpoenas and search warrants, and what to do when the feds kick down your doors. In today's presentation, you're going to get some great information on how to detect ITAR, EAR, and FTR violations, and how to write and submit voluntary disclosures, as well as get step-by-step guidance on how to react to subpoenas and search warrants when the feds come knocking at your door. My name is Shariah Johnson. I, along with Tom Dustman, are the co-chairs for the NADEX Education and Outreach Committee, and I have the honor of introducing our presenter for today, Mr. Jim Bartlett. Jim is an attorney specializing in international trade and is the author of Bartlett's Annotated International Traffic in Arms Regulations, Bartlett's Annotated Foreign Trade Regulations. He's the co-author of the textbook, United States Export Controls, 7th edition. He's an editor of the Society of International Affairs Pocket ITAR, editor of the Export Import Daily Update, the Daily Bugle, and has been associate editor of the ABA Public Contract Law Journal since 1993. Jim is principal of Full Circle Trade Law, PLLC of Washington, D.C., and he's also a partner of the international trade audit firm, Full Circle Compliance, BV of Netherlands. He has taught U.S. trade law at the Netherlands Defense Academy, the University of Liverpool, and the Luis University School of Law in Rome. Jim was previously senior counsel, export-import law of Northrop Grumman Corporation. He was the director of Global Trade Controls Harris Corporation, assistant professor of military law, U.S. Naval Academy, assistant general counsel, U.S. Defense Intelligence Agency, and spent several years as a prosecutor and criminal defense counsel. Mr. Bartlett's professional qualifications include a Juris Doctor from Albany Law School, Union University, a Master of Laws, Government Procurement from George Washington University Law Center, and he is also a licensed U.S. Customs broker. Jim is admitted to practice law in the courts of New York, Pennsylvania, Florida, the District of Columbia, various U.S. district courts, the U.S. Court of International Trade, the U.S. Court of Appeals for the Federal Circuit, the U.S. Court of Appeals for the Armed Forces, and the United States Supreme Court. He is also certified by the Ohio State Attorney General to provide export-import legal advice to Ohio colleges and universities. Jim is a current member of the U.S. State Department's Defense Trade Advisory Group, DTAG, the U.S. Commerce Department's Regulations and Procedures Technology Advisory Council, RABTEC, and the American Bar Association's International Law, Export Controls, and Economic Sanctions Steering Committee. So lots of awesome accolades there. And before I turn it over to Jim, so a few housekeeping notes. If you could please put your questions in the Q&A function that you'll find at the bottom of your screen, not in the chat function, and we'll be answering questions for you live. So please feel free to chime in and put your questions in the chat, and I will make sure to grab Jim's attention so we can answer your question if it's pertinent to the discussion at hand. There will also be time at the end of the presentation for additional questions that you may have. So with that said, Jim, the floor is now yours.
Whoops. Let me share. Can you see my screen?
Yes.
All right, let me go to the full presentation mode here. And first I want to say, Shariah, thank you very much. And I hope you recorded that because I'd like to have that played at my funeral. That was that was such a great, a presentation. I'll definitely want to save it. Well, ladies and gentlemen, it's a pleasure to do this presentation. It would be more of a pleasure if we were all in the same room because I like to see hands go up, faces, and I like to have quizzes throughout. But we're going to do it this way, and I think you'll enjoy it. So let's roll. Here's what we're going to talk about. You know what the violations are, I'm assuming. This is not an introductory course in ITAR or EAR regulations. I'm going to have to assume that you know when you have a violation. What we're going to talk about is the consequences of the violations, how the government discovers them or how you can discover them, and what you should do if you find a violation. Now, I provided handouts, which you should all have. I gave you a list of the import-export disclosure regulations in their original format so you can go and look at them. I will be summarizing them, but you need to have them handy. If you are actually going to file a disclosure, read the regs. I've got a sample federal search warrant for you. We'll be talking about what to look for. Then there are the ITAR, EAR, and CBP, the Customs voluntary disclosure and enforcement provisions. I also gave you a sample notice, an original notice, and then full voluntary disclosure to DDTC, and a similar voluntary self-disclosure to BIS, and that's Bureau of Industry and Security, and the Office of Export Enforcement. I just took one of the ones that I have done and redacted the client's names out of it, so you'd have something to look at that works. Okay, the most frequent export violations, and if you look over the penalties that are announced by state and commerce, not customs necessarily, because voluntary disclosures are of violations generally that may not be discovered by the government unless you tell them, whereas customs violations are like speeding tickets. You get them regularly, and ITAR or EAR violation is less frequent, but can be much more of a penalty if it goes the full length. So most of them come from misclassifications. If you don't know whether you've got a defense article or a dual use article, you don't know which book of regs to look at. Unauthorized electronic exports are the most frequent source of unauthorized exports. Telephone calls, faxes, well, you don't use fax much anymore, but emails especially result in a lot of violations. Retransfers by your customer over in Europe, that will result in your violation if they retransfer what you send them. And the question will be, were you due diligent enough to prevent them and tell them what they had to do? And often it comes back to bite you. Every license comes with authorizations, with provisos, and if you exceed them, you go on the list. Exemptions, ITAR exemptions, EAR exceptions, traveling with laptops, and then at universities, there's a whole range of ways to get into trouble at a university, mostly involving foreign students and visiting professors and pre-publication and so forth, because scientists always like to publish. Sometimes what they have in their papers is export controlled, and it's not always fundamental research. Okay, I think there's nothing better than a bad example. When you're approaching a village and you see heads on pikes outside the village, you know they're strict there. So in the same way, when state or commerce publishes a penalty, it's something to look closely at because it could happen to you. Now, here's a quiz. I can't see your hands, but I'd like you to think to yourself, what do all these companies have in common? They're all exporters and importers, yes. And actually, the slide was created over 10 years ago, but I love it, so I keep using it. The answer is all of these companies paid fines, big fines. So see, it just doesn't happen to only Boeing or only Northrop Grumman. It happens to a lot of companies, and let's make sure that it's not your company. Here are some recent bad examples. This one just happened earlier, last month, and that's let me move my little slide here, get rid of this thing so I can see. Dynatex was charged with exporting EAR 99 articles. Now you think, well, you can't get in trouble with an EAR 99 article because those don't require licenses. Well, yes, they do if they're going to denied parties or to companies that are on the bad boy list, that is sanctioned or listed by either Commerce or State Department as being a destination that you can't use. So in this case, there was almost $500,000, which if you look at this company's profits last year, That's 10% of their profits. If you did that with Boeing, it would be in the billions. So you don't want to give up 10% of your profits. And that was a civil settlement, which means it could have been a lot more if they hadn't settled it. But they were warned. They claimed the end user was not their customer, but was the customer of their distributor. So they were shipping things to their distributor, and then their distributor was turning around and selling them to the real end user. They knew about it. They continued anyway. They had no particular mitigation, and so they got slapped around. Here's another one. Whoops. Well, not my slide. There we go. This is Keysight Technologies, which is the last DDTC penalty. Let's see if I can get rid of this thing. I got to get rid of this. No, don't leave the webinar. Okay.
So while you're fixing that, Jim, so just a quick, so some participants did not get the access to the handouts. So Heidi just dropped a link in the chat. So if you didn't get it prior to, you can access that link in the chat to get to your handouts.
Okay, here we go. Yes. And if you get them afterwards, that's fine too. But a lot of times you're taking notes, or you even have a copy of this presentation, which was in the handout, but you want to see the real thing. Okay, what does a voluntary disclosure look like? I've given it to you. And you don't have to really go hunting for the regulations. I've given them to you. Okay, with Keysight Technologies, $6.5 million. And that's because they were involved with exports to China and Russia. So there was national security issues there. And they argued with State Department because DDTC found out from customs, there were some things that were shipping as ER-99 and came in and said, you know, these things, we believe they're on the US munitions list. They argued. They filed a CJ, a commodity jurisdiction, which came back, yep, it's on the US munitions list, so that it is. Okay, I beg your pardon. I should have turned this thing off, but I didn't ahead of time. All right, so they actually argued the case and continued to export as EAR-99 while their CJ appeal was pending. You know, you can't get any dumber than that, unless you're intentionally trying to violate. But they, you know, and the State Department decided they were stupid but honest. It was a late voluntary disclosure. But they did cooperate by waiving the statute of limitations, which means that State Department or Commerce Department or the Justice Department has 5 years to bring charges against you. And if it's pushing the 5 years, they'll ask you to waive that. So it tolls the statute of limitations. They did that. And they started their remedial actions before it was necessary. Okay. Darling is one of my darling cases. This is an example of a case that State Department said, you know, people out there just need to get the word. A lot of people have empowered officials who don't know much. You know, we've bought other companies. Some of my clients have bought other companies. You go into I went in one time, I want to speak to the empowered official. And they said, oh, that's Dr. Jones. Dr. Jones, I want to talk to you about ITAR compliance. Listen, counselor, I don't know what the initials ITAR stand for, okay? We've got this lawyer downtown and he tells me whatever to sign. That is not a legitimate empowered official. In this case, Darling had a lot of small violations. And when state went to look them over, they found out their empowered official had no training in ITAR. He did not have a proper authorization letter. So they slapped him with a fine. They did not meet the required empowered official definition. They ended up paying $200,000 of a $400,000 fine. Okay, you recognize this guy? He's one of my poster children. Poster child, Dr. John Reese Roth, professor for 30 years, had a contract with the Air Force, and he was running space at the University of Tennessee, and now and he's out now, but he went to prison for 4 years for ITAR violations. He misclassified his stuff as ER99 to begin, and allowing Iranians and Chinese, and he took controlled data on his laptop over to China, and he thought that there was no violation if he didn't show it to anybody. But what really got him punished, and I talked to the prosecutor in this case, by the way, he said that first off, he was warned by the export control officer of the university, and he said, "Hey, I don't work for you anymore. Get out of my space." He did not voluntarily disclose. In fact, the worst was his failure to cooperate with FBI and DDTC. He told the FBI agent to get out. He said, "Listen, this is a federal contract, so I don't have to worry about ITAR or whatever." Well, he went to jail and found out about it. Okay, consequences. I think we've talked about some of them. Yes, you can dodge your responsibilities, but generally you can't dodge the consequences of dodging your responsibilities. So you can go to jail. Your stuff can be seized by customs, and that's going to take you, even if it shouldn't have been seized, it's going to take you maybe 13 days to get it out of detention, and it's going to be costly, burdensome. If your name is in the newspaper, like these companies that I just showed you, it's bad press. Some of your customers may avoid doing business with you if they think that you don't know what you're doing when it comes to ITAR compliance. And of course, you can lose government business. Now, criminal prosecution, well, jail, millions of dollars in fines, but the prosecutor has to prove that you knew what you were doing, called mens rea. You knew what it was wrong, you did it anyway. So they want to show that you knew it. Now, you might get a chance to do like these other companies did, where they were offered an opportunity to settle the matter, not admitting that you did anything wrong, but pay for a settlement. And this often happens when State or Commerce figures out you just don't get it. You got to be slapped around with a fine. Now, most voluntary disclosures, 9 out of 10, maybe even higher than that. I didn't check the latest statistics, but they are never come before the press because they are privately settled. But if it goes to a consent agreement, then it's going to be published. Okay, if you're going to be prosecuted and put in jail, then the prosecutor has to prove export was not authorized and you did it willfully or with reckless disregard. If you use the defense, "I didn't know I needed a license to export," that's not going to do it for you. Because in this case, ignorance of the law is no excuse. Those laws are published in the Federal Register, US Code, and you are expected to read the entire thing. Now, I go through the Federal Register every day in order to publish the Daily Bugle, and I can guarantee you it is not entertainment. It's something you need to know, but when it comes to your particular violations, you need to pay attention to the law. How are these things found out? Well, you can tell the government, or they can find out. You don't want them to find out before you find out. So you do audits and assessments in order to discover your weak points. You should have a hotline. You do due diligence when you're going to buy another company, and you'll find out what their problems are before you buy them. And you can ask the government, help desk and advisory opinions and VDs and so forth. Be careful about asking a help desk, is it okay if I ship night vision to China without a license? No, don't do that, because now they suspect that you don't know what you're doing, and they may come out and take a look around. In fact, if they have proof that you have something, that you have unlicensed or you have information in your company that would lead to a conviction, then they can get a search warrant, or they'll send you a subpoena. Government investigations go on with a wealth of investigators. I'll show you those in a minute. CBP, of course, inspects what goes out of the country and what comes back in randomly. And many times they'll find a problem. There may be whistleblowers in your company, particularly if you fire somebody, a disaffected employee who's been fired or disciplined. will many times go right and blow the whistle on you. And by the way, for customs violations, they can get a reward for that, which is a percentage of whatever fine you haven't paid. Not so on the export regulations. Okay, agencies may contact you or your employees. I've had them call my employees at home and ask them about items that were made by our company. So train your employees to say, I'll take your name and number, but I'll have a company representative call you back, and then get in touch with the law department or with the export supervisor, because you don't want to make statements to somebody over the phone. For one thing, you don't even know if they are a federal investigator. They might be a competitor. Okay, here are the primary export control agencies we worry about. Office of Foreign Assets Control at Treasury, they're in charge of embargoes and sanctions. So when the president puts somebody on the bad boy list, then it goes to Treasury Department to enforce it. Here is the sexy stuff that is ITAR controlled by the State Department's Directorate of Defense Trade Controls, the DDTC. Those rules are in the ITAR. Now, Commerce Department controls just about everything else. And it's, you used to say the military stuff was in the ITAR and the civilian stuff was in the EAR. No more, because a lot of things moved off the ITAR back a few years and now are controlled by the Commerce Department in the EAR, mostly 600 series items, but there are a lot of things that are controlled. And also, don't forget about the foreign trade regulations. The FTR has the rules for filing those electronic information reports, the EEIs. And then there is, of course, last but not least, customs. They look at everything going or coming. If it's physical, they do not inspect electronic transmissions going in and out. We have
a quick question
okay.
in the Q&A. It says, I see Libya on the slide, but I thought this country was off the sanction list. Please confirm.
No, Libya is not off the sanction list. They're still a part 126 ITAR country. And also, well, I have actually a whole list of these countries that'll coming up in a good slide. But that's it's a good question. But no, they're still on the list. So for the ITAR, it's going to be different because you need a license for everything, except where an exemption applies, like Canadian exemption. On the EAR, you only need a license if it's required in the EAR. We'll talk about that in a minute. ATF regs, they don't license exports, but they do have taxes on exports. And they, of course, review imports. And then you got a whole new set, another set of export regulations under Department of Energy and the Nuclear Regulatory Commission. That's mostly power generators, peaceful technology. If it's a weapon, it's handled by the ITAR. Now, one of my favorite agencies I work with a lot, I'm on the RAPTAC, so I see the director of the Office of Export Enforcement on our quarterly meetings, and they're great guys to work for. They really know the EAR. That's all they do, really. They enforce the EAR. FBI, they enforce everything, so they're not specialists. OEE is specialists. There's one little flag missing there. They now have another office up in Minnesota. They're spread around, and when you file a VSD, it goes to the nearest OEE office, and they'll be contacting you. Now, watch out for export enforcement outreach visits. They say the reason they're coming by is educational, to meet you. But remember, you can't be prosecuted for a crime unless the government has proof that you knew it was wrong. So if they've got the goods on you, it could be that they already know you're doing something wrong and they want to come by and discuss it. If you do it again, now you can't say you didn't know it was wrong. So be careful about those friendly visits from agents. They may suspect you and they need proof of it. They will inform you of requirements while you're there or ask questions that may get you in trouble if you give the wrong answer, or if you continue performing an illegal act after being informed that it was wrong. Just remember, police officers, and by the way, these OEE agents are 1811s. That is, they carry guns, they have a badge, and they can arrest you right there on the spot if you want. And you know, the thrill, I think, of any federal agent is bringing you outside of that company in handcuffs, and the CNN is there watching them, you know, bring you out, you know, they got you. I mean, they want to stop crimes. DDTC is a little bit different. They don't have agents with guns. If it's serious, they will turn it over to the Homeland Security Investigations or FBI. But if you get one of these agents visiting you, you got to ask yourself, why did they come here to see me? I mean, was it just a friendly visit to get acquainted, or was somebody in my company possibly engaged in a violation that I don't know about? You got to find that out by doing your due diligence, especially audits and self-assessments. How about a subpoena? We're going to talk about subpoenas and search warrants now. A subpoena is a piece of paper. Okay. It can be a subpoena duces tecum. It can be a subpoena testificandum. That just means you either got to give them a piece of paper or go into court and testify. Just get that to your general counsel. Sometimes they come in the mail, but usually they are served by a law officer. But don't destroy anything there that's listed in the subpoena. You may remember a big case that happened about 10 years ago, where a lot of people in a major audit agency went to jail, and it shut down the audit agency. They became bankrupt because their client got a subpoena, and they had a policy of destroying documents after 4 years. Well, there were some documents that the subpoena asked for that were 6 years old, 5 and 6 years old. So they went up there and they said, well, we can destroy them after 4 years. So they started shredding all these documents that were listed in the subpoena. And that is obstruction of justice. And some people went to jail over that. Okay, a friendly search warrant. Once in a while, especially if you sign an NDA, it says you may not give that to anybody outside your company, except, there's always an exception, a court order, a search warrant lawfully issued. So I've had agents come in and say, we like to see the plans that you got from this other company. And I'd say, I'll need a search warrant if you want that, or subpoena. And so they deliver a friendly search warrant, says, give us this. And so we give it to them, and then we inform the other company that we had to give it up. But the ones we're about to discuss, you don't know they're coming. And these are the ones that are tough. Okay, let me, before I tell you about this, I'm presenting this from the point of view of a defense counsel. Okay, a defense lawyer. Now, I preferred being a prosecutor when I was in the government. You win more cases, for one thing, but I like to see criminals go to jail. On the other hand, my clients generally are not criminals. They're stupid but honest. They just didn't realize what they were doing was wrong. But remember, these police officers are out to make a bust. They want to get the evidence. They want to see a conviction. They want to see fines. They want to see somebody go to jail. They high five when they get that. So my advice to you today is not to keep criminals from going to prison. I hope they do, but to keep you from suffering the consequences of a charge perhaps that you shouldn't have, or to prevent you from being subject to penalties. Okay,
Jim, we have a question. Do you recommend purging documents and files that are not required? For example, old import-export files.
Absolutely. Because if they're not there, nobody's going to get them, provided you get rid of them before the subpoena comes in for them. Okay. Now, be careful about the date that you destroy them, because there may be a requirement in like a government contract, to keep the documents until the contract is completed. That might be 6 or 8 years. So just make sure that you keep a record of when you deleted it, destroyed it, and why you destroyed it. Not because you got a subpoena, but because it was time to do it. Yes, I do think it also saves storage charges. Now, if a subpoena comes in, though, there are a lot of people who save things on their laptops and they're not in a file. So you have to go out with an order, and this usually comes out of your legal office. It goes to everybody who says, if you have any items that are described below, quarantine them. We have to know, do not destroy them, quarantine them, because they are subject to retrieval by the subpoena. You don't want to tell the government that you had a bunch and you deleted them. Okay, so you're sitting around one day and we're going to say, whoa, your phone rings and you hear federal agents that are our labs, and they got a search warrant and they're picking up our computers. What do we do? Well, that's not the time to first think about it. You should have, don't get scared, but it frightens people when men come in with guns and start taking stuff away. So you need to know how to be prepared. Here's what to do when you serve with a search warrant. Call your security officer, call your lawyer, do that right away. And you should have a directive in your company. I call it break glass in case of a search warrant, a directive that explains, here's what you do. You've got the steps that I'm covering, the number of your general counsel or the lawyer. If you don't have your own company lawyer, your small company, one that you keep, a card that you keep in hand just in case. And then the step-by-step instructions as to what to do. And you need a form in the book for what people are going to write down after the search is over, because that's going to be very important in defending yourself from any charges or just getting down to corrective actions if you've had problems. So here's what to, now we're going to assume that you call your lawyer and you get voicemail. Okay. And you say, there are about 8 police officers in here taking our computers right now. So please come over as soon as you can. Here's what to do before security arrives. Say, please wait until our lawyer and our security director can be present. When I give this presentation live, I always scan the audience and ask, are we have any ex-police officers in the audience? And usually you could get some. And I'll say, have you been engaged in search and seizure, based on a search warrant? Oh yeah. I said, if they say, please wait until our lawyer can be here, would you wait? Hell no. They say, well, the only time they'll wait is if it's more like a friendly warrant where they want certain documents, and they'll get them a lot faster if your lawyer comes down and leads you right to them. Because if they have to start opening drawers and everything, they could be there all day. They don't have to wait, but it is a good idea to ask them if they would wait. If you politely ask, you never can tell. They may wait. So you say, next, may I please see your identification? When I was at Northrop, we had a police officer, so they said, visited in the lobby and called the names down of 2 of our engineers. And she showed a badge and she asked them for copies of these documents, which are ITAR controlled. She said, thank you very much, and left. The next day, they reported this to the security officer and the export control director. And they said, well, who was it? I said, oh, wait, we don't remember. I said, you can buy a badge in a dollar store. How do you know it wasn't somebody from Boeing? I mean, wanting our secret, well, we tracked it down finally, and it was Defense Investigative Services, and she had a legitimate reason for asking the question, but always ask for identification and take a look at it, write it down, examine the IDs, write down the badge number of the agent in charge. They are required to give you that information unless they hear screams coming out of the back room or something like that, or toilets flushing, then they don't have to wait. But ordinarily, they will do that. They will be polite. I want to see a copy of the search warrant. Why do you want to see that? Because a search warrant is what authorizes the police officer who finds evidence they can use against you to submit it into court as evidence, because your lawyer will say, I object to having that evidence submitted. and the judge will have to decide whether there was an authorized search warrant. And it has to say where you're going, read the warrant. It has to describe where they're going. Here's a sample warrant. Okay. This is a federal warrant, and the property is going to be located right here in, District of Columbia, wherever, and identify the person or describe the property to be searched. So they're looking for documents, customs or export documents at this particular location. We had a small office one time many years ago where a search warrant was signed, and everybody got all frightened. They were unplugging computers and whatnot. And we had a lady with a backbone, and she said, "Sir, may I see that search warrant?" She said, "This is not Ajax Company, 1001 Main Street. This is 101 Main Street. You got the wrong company in the wrong place." And the agent looks at it and says, "Abort, abort. They got the wrong place." And that happens occasionally. Also, it will say the offices at this particular address. Well, what if you have a warehouse in the next block? Well, police officers know how to get around that. They see they're limited to 101 Main Street. They'll say, "Do you mind if I search if you got anything to hide?" Say, "Oh, of course not." "Well, do you mind if I search your warehouse next door?" "Oh, of course not." You know what? It's no longer a search warrant search. The seizure that results from that did not occur from a search warrant. It occurred from a permissive search because you just said, "I don't mind if you go over there." So don't agree to an expanded search. You don't know what they're going to find. It may not even be something you know about. You'd like to know ahead of time. So don't consent to anything. You don't have to. They don't need your consent to search. They can go open locks, break down doors, anything, but they will ask you for consent. So he'll say, "I'm here to examine your records. Do you have any objections?" And you say, "I'm sorry, sir, I'm not authorized to make those decisions. But if you'll wait a few minutes, our lawyer or our security officer will be here and, they can do that." Always fall back on the fact that you are not authorized to give permission, because you're probably not anyway, unless you happen to be counselor of the vice president or president of the company, you're probably not authorized to give away your stuff. Okay. Now, don't ask questions or make statements, because they will immediately begin asking you questions and hope to receive an admission. And the admission of an employee will go against the employer. So you may know something that's going on wrong that your boss didn't even know about. Tell your boss first before you tell a federal agent. You don't have to answer any questions unless you're subpoenaed to go into court and sit on the witness stand and swear to tell the whole truth and nothing but the truth. But if you do say something, make sure it's not false, because it's a felony to give false information to a federal agent. That's what's her name? The lady who cooks, and she went to jail. I can't think of her name right now, but she was being, who's that?
Paula Deen?
No, not Paula Deen. No, I think she got in trouble too, but it was for something different. No, this is the one who went to prison. She was accused of
Martha Stewart.
That's it, Martha Stewart. She was accused of violating SEC laws or whatever, which it turned out she didn't do, but she lied about something when the FBI was interviewing her. So she went to jail for that. If she'd have just kept her mouth shut, she wouldn't have gotten in trouble. Okay, here's the officer. Where are your international trade records located? You play dumb. I'm sorry, I'm not authorized to speak for the company, but if you wait, just be polite, because if you're rude, it's like going through customs and the guy says, "I want to see that bag." And you say, "Listen, I'm in a hurry and I'm a taxpayer. I pay your salary." I'll tell you, you're going to be in there a long time. He's going to look in your socks, because he has the authority. Same thing with an officer with a search warrant. He will do whatever he wants. So be polite, and it may go a little easier for you. If you're in a cleared facility now, agents can go in open up safes and look at top secret documents, but warn them that there is classified material in that room if you open that room. And ask them if they're cleared, because otherwise you got to go around the NISPOM and you'll be filing all sorts of security violation reports. It wasn't your fault, but it's still a lot of paperwork that in some cases the agent will say, okay, I will have Agent Jones be here in about half an hour, and he or she can go in there and look at the stuff to see if it meets our requirements. Okay, you don't have to open doors, you don't have to unlock anything, but they will take an axe and smash it, if you don't unlock it. They can break locks, they can take acetylene torches to safes and whatnot, and they don't have to pay for it either. So if you want to preserve your furniture and you figure they're going to get into it anyway, then you may say, well, okay, I object to you looking in here, frankly, but if you're going in anyway, I'll go ahead and unlock it just to keep it from being smashed. That's not a permissive search. Send non-essential employees home. Once again, I ask my police officer friends in the audience, I say, do you allow people in the room to go home? Hell no. They don't want any witnesses getting away. But sometimes, especially if it's a targeted search for legal documents, for example, whatever, for export, they may say, oh, these other people, they can leave. If they will allow other people to leave, send them home, because some people like to chat. And here you got Chatty Cathy, who goes up to the FBI agent and says, I knew this was going to happen. I've been telling my boss for weeks, we cannot export that stuff without a license, And he's jotting it out. Don't say, you do say what else, and blah, blah. She has just become a witness. So you don't want that person to talk to the cops. Monitor the search. If it is allowed, and usually it is, assign a senior employee to walk around with the agent as the agent searches and seizes. Keep good notes, a list of all the seized items. Say, excuse me, could I just see what that is you're taking? Now, they are supposed to keep a list anyway. And generally, at the end of it, they'll say, would you please sign this receipt? It shows what we're taking. I'm not authorized to sign. Why is this? Because I tell my police officers, I've designed a form in tiny little print down at the bottom. There's a big line where it says receipt. It says, I authorize all of these items to be removed from this site. And we convert that into a permissive search. So don't sign anything. However, basic rule, never fail to be respectful. Don't impede the investigation. Not only do the guys have guns, but you may end up like Professor Roth, getting charged just because you had a bad attitude. And do not give false information. Now, after the search, you got to report everything. A copy of the warrant, identity of the officers, a list of items, and try to remember and ask all the people who are in the room, did any of you make a statement to the officer about anything? We need to know, our lawyer's going to need to know. And did any of the officers make statements to you? We need to know that. Now, that's the end of the search and seizure advice, but let's talk about the violations that may be the cause of that search.
And Jim, quick question. Would you always recommend to have someone else with you in the room? I think based on your last statement, like don't be in the room by yourself with the agent, have someone else to be a witness or that can recall the information.
Absolutely. Because if the agent later says, and Ms. Johnson told me, yes, we've been illegally exporting for a long time. You can say, no, wait, I never said that, and I've got my friend here who can back me up on that. Yes, you should have several people there, but sometimes they won't wait. In fact, they can perform a search on an unoccupied building, and you don't have to be there. It's just that if you are there, it's much better for the company because now you know what's going on. Okay.
We have two more questions that came in.
Okay.
Are you allowed to make a video recording of the officers while they are conducting the search?
When you say allowed, that's up to the police officer.
Okay.
just remember he has a gun, and if they say no, no photographing, you don't want to argue with them. It would be best if you make a photo of, if you make it, yes, or if you can have someone do it that's in the corner, yeah, if you can get a videotape, by all means, record it. But the police officer may tell you not to, and you don't want to be come up against that. Another question?
Oh, no, the other one was about the presentation. So no, that was good.
Okay.
Thank you.
To begin with, you want to get to the violations before the government finds out about them. But if you disclose something as a violation that is not, then that shows how stupid you are. So you ought to confer with a lawyer before you submit information that may be an admission of a criminal act. Never do that. But once you decide that it's okay, well, then you got to have all the facts. And I said, see handout sample incident report. I apologize. I didn't include a sample incident report, but I have one. When somebody calls me in my office and said, we had, I think we've got an export violation, I will say, fill in this incident report. It'll save you a lot of time on the phone describing it to me. And I can provide that afterwards. Always report to your empowered official, your law department, your director of trade controls, to take ownership. Now, save everything, because they may come in with a subpoena, and if you've destroyed it, it will be bad for you. Why should you voluntarily disclose, and when, and then how? Okay, let me first give you some terminology. And knowing the right acronym distinguishes you from those who don't know the right acronyms. In other words, if somebody comes up to me and they say, oh, I filed a VSD with the State Department for an ITAR violation, I know they're not experts under the ITAR, because the ITAR, you file a VD, not a VSD. In fact, whenever I'm at around senior commerce officials, I always bug them. I say, what's the difference between a voluntary disclosure and a voluntary self-disclosure? Because if somebody else does it, it's not voluntary, right? And they usually have some smart aleck response like, well, we didn't want to have VD in our regulations, But just remember, it's a VSD if it's commerce, if it's census, if it's Department of Justice. It's a VD if it's State Department, and it's a PD if it's a CBP, Customs and Border Protection disclosure. It's called a prior disclosure. And a great thing about prior disclosures is you can do them on the phone, and you cannot be punished for a customs violation unless it was fraud if you report it in a PD and pay whatever duties were owed. So let's say you're going through your records and you thought, oh my gosh, we should have paid $10,000 duties on that shipment, and we brought it in as duty free, Oh boy. Well, if you disclose it and you pay whatever duties are due, you will not be penalized with these huge penalties, which they can do if they catch you before you disclose it. Treasury Department and the Justice Department also have disclosure provisions. I've listed them for you, and we don't have time to really go into it right now. But why should you disclose, really? And when should you do it? Early or later? Should you audit first or wait? And then what's the format? What do you do? Okay. Well, to begin with, everybody makes mistakes. David Trimble, who was a director at DDTC a few years ago, said, every exporter makes mistakes. And if you are not disclosing them regularly, I know you are either covering them up or you're too stupid to know you are making mistakes, because it happens to everybody. So should you disclose? Well, the word voluntarily there means it's not required. So if it's voluntarily, why? Well, for one thing, it avoids getting a directed disclosure, which is not voluntary. And that's where they take charge and they tell you what to send them. You don't want to be in that box. Reduces the likelihood of prosecution and penalties. It's built right into the regulations. It says in OFAC, for example, they can't give you more than 50% of the maximum if you came in and disclosed. It stops the repeated violations, and it even gives you a sort of a halo effect with the regulators. I find if you go in and tell, then it's much less likely that you'll get a penalty. It's like you hear your glass break, a baseball comes through the window, and you hear a knock on the door. Mr. Bartlett, I'm really sorry, but I just broke your window. And tell you what, if you won't tell my dad, I'll come over and mow your lawn 2 or 3 times. I say, okay. But if a little SOB runs, you look out the window and he's running and hiding under the bush, now you're going to go over there to his old man and say, look, your son just broke my window. It's same thing with the government. If you go in and say, I screwed up, I know I screwed up, I have taken all these steps, then you are not going to get hit over the head and thrown in a box like Cool Hand Luke. This also may bring money to an area where you need money. It may bring new employees to an area that's understaffed. Because remember, these voluntary disclosures are signed at the highest level and sent. And before your company CO or even empowered official is going to assign one of these things, they're going to want a full investigation. And if you need help, you may get it. Okay, but there may be reasons not to disclose. For one thing, you no longer have an attorney-client privilege. If you've got something really terrible in there that is going to be disclosed, maybe it's not even an export violation. Maybe it's money laundering or something, who knows, that you act, and you don't want that out. If you put something in a voluntary disclosure, it's available for everybody, for the government to see. You may still get prosecuted. It could go public in a consent agreement. It could enable your board of directors to get sued by shareholders. Some people, if you report they did something wrong, will not cooperate with you in the future. And also, you can't apply for a license to do something you've been doing illegally for a long time without first putting in a VD or a VSD to ask, okay, I did it wrong in the past. I realize that now. I've taken these corrective actions. May I please have a license for the next one? Don't go in and ask for a license for something you've been doing for years, because sometimes customs picks that up. It comes across, here's the same classification number, but now it's ITAR or EAR controlled. Before it was ER 99. Now it needs a license with someplace and it's got a license. Well, why did they get a license for the past 5 years? They'll come and knock on your door and ask you about that. Results. What happens when you disclose? Well, it may come back and say, okay, thanks. We've decided it was no violation. That doesn't look too good, because that means you don't know what a violation is. Mostly the greatest examples are minor violations. See sample from OEE. I'm sorry, I didn't include that. When I do these in person, I have opportunity to pass all these things around. But there's a big red thing on the top of a piece of paper that says, warning, what you did was not that much. We don't care. We're happy with your, but you get this big warning to try to scare you. State Department gives you a letter that says, thank you very much. We've determined that you've taken the proper action. Or it can go to a charging letter. Charging letter is what precedes a referral to the Department of Justice, although usually State or Commerce will give you an opportunity to enter a consent agreement. If it's too serious for a consent agreement, or if you just don't want to consent, then it goes to Department of Justice for criminal prosecution if they agree to accept it. They're called consent agreement at state, settlement agreement at Commerce, a non-prosecution agreement or a deferred prosecution agreement with Department of Justice. Now, when? Well, all the regs say, report as soon as you know you have a violation, immediately. And then follow up with a complete report. If it's under the ITAR, 60 days. Under the EAR, they give you 6 months. Customs, within 10 days. My advice is, disclose early and often, but frequently, and I've submitted over 100 VDs, and our company policy, in fact, at one of the companies I worked for, is not to send in a disclosure until we know what happened for sure. Don't set off the fire alarm without knowing if it's just smoke. And sometimes you go down there and an employee got a little excited and said there was a violation, where in fact, when you looked it over, you found out it wasn't. Or you had a license for it, they just didn't know about it, or it was eligible for an exemption anyway, and you're just not going to report it, or you're going to go backdate maybe the records to show what you did. Okay, you didn't write it down when you did it, you're writing it down now. So yes, you did violate the record keeping requirements because it wasn't written down when you did it. But let's face it, that's not serious. And you don't have to disclose every one of those things. Okay, you discover someone in your company violated the export regulations. Are you required to file a disclosure? I think, Shariah, I'm going to ask you this question because you're the only person I can see. Yes or no?
Are you required to file a disclosure?
Right.
No.
That's right. You're not, unless sometimes disclosures are required. Okay, so it's one of these things that lawyers love to say. It depends, okay. Here it depends, because there are mandatory disclosures. In the ITAR, in the EAR, you must report. For example, if you take ammunition or personal protective gear, body armor, what, overseas on an exemption and you lose it, you've got to report that. If you send night vision to China, you must report that. In the EAR, you send in a report and then later you find out that the facts were wrong. You reported accidentally the wrong thing. You must disclose to them to give them the right stuff. And also many licenses and agreements require you to report future incidents. DFARS is one. If you have government contracting, there are DFARS requirements that say if you are aware that there is a violation, you must report that. Now that doesn't get you, that's not a VD to state, but if you've got a state or Commerce Department law also broken, and it's a DFARS violation as well, then you got a multiple agency disclosure. Okay, what are the required elements? Well, there's a list in the ITAR and there's another list in the EAR of the things that have to be included. When, where, how. Identities, generally speaking, I don't report the identities of my engineers. I'll just say engineer A took this in his briefcase, engineer B, and that usually satisfies them, provided that there wasn't some intentional act. And it doesn't embarrass the person by having his or her name in a federal document like that. It has to be signed and certified. Same thing in the EAR. Here's a list of all the things that have to be in there. And I've given you sample initial reports and then also a full report with some fictitious words in it. Make sure you describe the mistake. Who, what, where, and why. Don't say mistakes were made, but you don't want to name anybody, or like some of these things, and State and Commerce, they'll come out with these VDs and VSDs at conferences and they'll say, oh, you got to look at this one. It's like, it's this thick and you have to get down to page 12 before you find out any facts. It starts, it was a dark and stormy night when the violation occurred. No, treat it like, I think you ought to treat it like I think of a slide on this. Yeah, make it look like a contract proposal. Make it look good, like you're selling something to somebody, because you are. You are selling your credibility. If you've done it before, own up to it. It's like, when I take a client who's got a drunk driving conviction in his record, he's got a new drunk driving charge against him, I put the client on the stand and I say, well, now, John, this isn't your first time, is it? Well, no, but, okay, that's better than having to come out from the prosecutor, So don't cut and paste old stuff. I've even seen voluntary disclosures that were submitted with the wrong company name. They used one off the internet, and don't put somebody else's name in your disclosure. It makes you look like a complete idiot. Now, they may give you a break if you got mitigating circumstances. It would have been authorized if you'd only asked. Okay, a lot of your exports require a license, but you didn't get one. Okay, well, if you could have gotten one, if you'd have asked, then that's a mitigating circumstance. And full cooperation, that means waiving the statute of limitations. Show them what you've already done. I never like to say, I'm going to do training. I always like to say, let's train tomorrow if necessary, before we submit this VD on Friday. Okay, because I want to say, I have taken corrective actions. We trained those employees. We brought in an auditor. We brought in a law firm. State and Commerce, they love to see you spend money, either as a fine or pay lawyers a lot of money. That shows that you're getting your mind right. Okay, and then they're very much impressed if you've got the results of an audit that discloses that they did find a few more things and you included them in your VD, and you're cleaning up every other thing. Okay, so aggravating circumstances, these national security risk, if you've delayed, you did it for a long time, management knew about it, but accepted it, or even worse, directed it. Some of the big ones, like, the Chinese ones, for example, you got emails where their lawyer says you can't do that, and they'll say they'll never find out. Untrue statements, concealing, hiding, or that Dr. Roth, who cares attitude, that will get you in trouble. Now, clean up before being forced to do it by the government, because they will come back with a statement. We want to see all these things done. Oh, I've already done all that. Well, that gets you a response that says, looks like this was well handled. That's the end of it. Don't say you corrected a problem unless you're absolutely sure it was done. Okay, keep copies of everything, because if you say we trained them all, I guarantee you, sometimes which happened to me, my empowered official said, we trained everybody. State Department called me up and said, we want to see copies of material and a list of the employees. I called my EO and I said, I need the materials. Oh, well, it was on the phone. I'm not sure who, and it was verbal. Okay, you just got me beat up by DDTC. So this time you're going to be punished. I'm going to come over and do the presentation, and I want to see everybody there. So always keep that. Okay, that comes to the end, but I do have some parting advice for you, and it comes from an old movie. Remember Cool Hand Luke? You've always got to have an attitude of cooperation, or you're going to get beat up and thrown in the cooler. And you remember, what we have here is failure to communicate, because Cool Hand Luke was being a smartass. So the boss said, you got your mind right? And he said, yeah, I got it right, boss. Quit hitting on me. So you and the government, same goal, 100% compliance. So get your mind right, at least make them think you got your mind right. And that will be a key to your success. And that brings us to the end. And I wonder if we have any more questions.
One quick question. Someone says, can we use some of your material for training purposes?
Absolutely. Yeah, be free. I do appreciate receiving attribution, and you can say, these are some slides we saw on the NADEC, and Jim Bartlett gave the presentation. He's not cheap, but he's not expensive. So if you need somebody, now it's just a little commercial here. I didn't insert commercials during the presentation, but I'm a partner of Full Circle Compliance. That's a Dutch company, and we specialize in US laws that apply overseas, primarily to Europe. But we also do audits and so forth. And then I've got several books. The Daily Bugle is free. And if you don't have the Daily Bugle, you definitely need to subscribe. I do it every day. I just released today's Daily Bugle. I check the Federal Register, and we also list on Monday, about 100 jobs open in the import and export community. And so you can get that by just letting me know. Any other questions?
I have a question, Jim, but just quick, I guess, for the audience that all of the handouts were put into the chat, so you can click on those and access those, but they'll also be available after the presentation. But I had a question about like OEE, when you say they have their outreach, right? And when they come to you, do they typically call you on the phone, or when you get an email, or how do they communicate with you? They're going to come over for some outreach education.
OEE will generally call you unless they think you've got something that they want right away. They don't want to give you a chance to prepare. I was doing training for a small company in California that only had 6 employees. And while I was doing the training on Zoom like this, a lady rushes into the room and says, there are 8 federal agents at the door, and I was doing the training. I said, hey, welcome in. I said, do you have a search warrant? No, we don't. Do you have a subpoena? No, you don't. Why are you here? Well, we just want to talk to people. So I said, well, then you don't mind if we do it right in front of me so I can hear what you want to talk about, right? I mean, what an amazing coincidence. But usually they will, if it's a polite, get acquainted. OEE in particular does get acquainted. They are told a new agent should go around to all the companies that are in their area that are major exporters, meet them, get to know them. My advice to you is shake hands, grin, serve some coffee and donuts. And it's what I used to do with customs when I was down in Melbourne. Orlando, we invite them over to play with our cockpit simulator and all that. They'd invite us to go over and watch the dogs sniff people. One day, I got a call from Customs. He said, Jim, this is Eddie over at Customs. You know what? Your freight forwarder just dropped a box off here that I haven't looked at yet. Because if I was to look at it, I'd have to seize it. And there'd be a lot of paperwork. So if you can get them to come back in the next 20 minutes, save us both a lot of paperwork. That's the kind of relationship you need especially with Customs, because they're local, But if you get an opportunity to meet these agents, by all means do so. If they're speaking in public forums, go up and introduce yourself, give them your business card, shake a hand. And then when you got a problem, you call them up and you say, hey, Bill, this is Shirai Johnson. Remember when we met that one? Yeah, well, I got a little problem I thought you might want to know about. I'm getting ready to file a VSD, but you can grease the skids, as we say sometimes, make it easier for the bad news to arrive. So that's something I recommend. Any others?
Awesome. Nope. Just someone says Daily Bugle is one of my essential resources. Thanks, Jim.
That's great. Well, we got about 10,000 subscribers. I figure one of these days I'm going to start charging them for it. When I retire, I can charge for it and I'll have something to live on. But I notice we've come to the end of our hour, but I'm available if for any other questions. And if people want to come on the Zoom and actually show their face or whatever and ask a question live, that would be fine with me too. So if we have any others, or you can get in touch with me at my email there or give me a phone call. Now, don't expect me to represent you for free, but a short phone call is fine. But I do this for a living. So I'm always happy to give free advice though to begin with. Anything else?
Awesome. Nope, that's all in the Q&A, Jim. I think
Okay.
Mike has the final slide and then we'll exit out of here.
Very good. Now, do you do a grade, do you do an evaluation at the end?
Heidi, will you jump in? I believe we do send evaluations post presentation.
I am very much interested in.
Yes, I believe we do.
I don't care about getting a lot of praise. What I want to hear is, you said this wrong, you didn't do enough, you did too much of this, or you didn't do enough of that, something like that. Or your office is messy or whatever. I benefit more by criticism than I do compliments, but I always enjoy the compliments too. So Heidi, if you have one of those, then that's good.
Yes, we do.
Great.
All right. So thank you everyone for joining us today. We appreciate your time. Jim, we appreciate you and all of your knowledge. Thank you so much. Everyone, please stay tuned for the next webinar. You'll see information on that. The topic will be innovation in cross-border payments and foreign exchange. And that's all for today. Thank you.
Thank you.